Hello and welcome to the Business and Banking Dialogue Show, a bi-weekly show which brings to you the best of topics from the financial world. Uh, Today, we are going to talk something a little different and not the general financial subject that we often talk about. Today, we are going to talk about data privacy. So, good evening and welcome to the show. My name is KK and I am the moderator for today's show. Ladies and gentlemen, as consumers increasingly adopt digital technology, the data they generate create both an opportunity for enterprises to improve their consumer engagement and a responsibility to keep consumer data safe. Customers and vendors give data trusting the data taker or the organizations which keep the data. What if the data keeper knowingly or unknowingly gives away data or data is stolen away from his organization? So let's look at what are confidential data that reside with third parties. It can be the applications like your email, web, OS, etc. In which there is a lot of data that is kept there. Folders, shared network folders, local folders, databases, cloud and third parties, removable media, physical locations, cabinet safes, test and development network. One of the common things that happens is a lot of data is there in your PC. But what happens when the PC is sold, scrapped? Your data is still there. So what is the process? What is the procedures? So that's the danger: financial, reputation, and abuse. All this is possible if data is not guarded. Citizens' data is not guarded. So, what are the governments doing about securing data privacy? In particular, what is India doing about it? So, to discuss about the data privacy protection and how India is preparing to protect its citizens, we have with us Mr. Sambamurthy. So, in a second, you'll see his slide, his profile. While the profile comes up, So, Mr. Murthy was Executive Director of Indian Bank. He was the Chairman of Corporation Bank till 2008. He later became the CEO of IDRBT, which manages the gateway for NEFT, RTGS, besides NFS for RBI. I mean, we all know about NEFT, RTGS. All those who are in the payment industry, they know it very, very well. So it's been a leader out there. So, ladies and gentlemen, just a few seconds for you to read his profile in case you haven't read and not known Mr. Murthy before. So, ladies and gentlemen, please join me in welcoming Mr. Murthy. Good evening, sir.
Good evening, KK. It's always a pleasure to be back there. Thank you.
Yes, thank you very much.
Once again.
No, always a pleasure, sir. And thank you for coming. We all know that it's raining very, very heavy out there, and there's a lot of floods and everywhere. Despite that, you have those challenges. You have joined. There is a little bit of a network issue. We understand that, sir. But once again, thank you so much for taking the trouble and joining. So let us get into the discussion. So India is also adopting data protection laws, just like Europe, which has adopted GDPR. Please, could you please give us to the audience a perspective or an overview of what is data privacy protection? How has it assumed importance suddenly in this world of data? As we know, data is like oil, like gold.
Thank you, KK. I think before you do that, because while I was joining, I got an SOS from my society to remove my car from cellar because water is filling up. So I had to delay a couple of minutes. Anyway, I've done that and then I came back here.
Okay.
I guess yesterday one cellar was full. Today they are threatening one more cellar will be full.
Oh, okay. It's that bad.
Okay. Right. Okay. So anyway, I think before why all this significance of data privacy, what the governments are doing all over the world, I think let us, need to understand the source of the issue. I don't say problem. It's but an issue that is arising out of several of our practices, citizens' practices. Number one. Number two, as you said, this is an impact. This has an impact on all citizens, not just bankers or IT people and all that. A very, very significant impact on all 1 billion people of this country. They need to be aware. So what is this issue? Or if you ask me to do that, as you said, data is the new oil. I think this is, said by a British mathematician, one Clive in 2006. Many people didn't notice it. Only last 2-3 years, we started talking of data is the new oil and new currency, new capital, and so on and so forth. So what British mathematician has said in 2006, 14 years ago, I think now it's probably haunting us. Let me say that. There is a positive aspect, and there is also a challenging aspect to it and all. See, if we look at it, what is this privacy problem? You see, when we talk of privacy, it's about information privacy and data privacy. That is the privacy of an individual, right? So if we look at globally, you say 7 billion population, right?
Yeah.
And then, we have 20 billion devices so far, and it's likely to go to 40 billion in the next 4 or 5 years.
Okay.
So you can imagine 20 billion devices extracting data. We are giving, in fact, some of them, in some cases they extract, some cases we ourselves voluntarily give. Imagine the amount of data that would be probably generated on a daily basis. Now people don't talk of daily basis. Now they talk of hourly and every minute. That how many YouTubes are downloaded, how many probably postings are done on Facebook, WhatsApp, messages and all that. So this has created, and mountains of data. And then a lot of these companies who are in this information business started collecting it very indiscriminately. So the policy is that first let us collect the data and then later on see what we can do it. So there was no purpose, a defined purpose. There is not even known purpose. Even the citizen whose data they are collecting and storing, even the citizens are not aware what kind of data they collect and all that, right?
Yeah.
So that is one problem. Coming to Indian Sea, we have these mobile devices are one source of data generation and all that, right? We have almost close to 1 billion mobile phones, and we have 600 million internet users, right? And then we have about 400 million WhatsApp user base, and 200 plus million Facebook, and a lot of other things that we have. We download a lot of apps and all that. Yeah. So all these devices are also generating, collecting, storing, processing a lot of data, which is not known to citizens and all that. You can imagine we are in fact the second largest base of internet users. One of the, I think probably second largest mobile subscriber base here. And top 3 so far as WhatsApp social media platform is concerned. So much of data is there. No one has got an idea what is happening to this data, right? So this is all over the world, and what is happening today is whatever we buy, wherever we go, whatever we watch, and then whatever we do at home, thanks to some Alexa and all that kind of stuff.
Yeah.
So everything is watched. Everything, there is a data. In fact, the joke that goes around is probably these platforms and the devices know more about us than we know about ourselves, right? So it can be used for a good purpose. It can be used for a wrong purpose and all that. So why it's happened? It's not that only these entities, organizations who are in the information business, who are in the internet economy business, it's not that they only collect it. Many cases, we also have relinquished this data. Want to download Facebook, you want to probably subscribe to Facebook, you would ask for so many permissions and all that, we would give. We download some app and then ask for some permissions. He wants not merely WhatsApp. I think each of us will have at least 20 apps on an average who are probably using a lot of, not merely for our own financial purposes, entertainment purposes, business purposes, official purposes, even domestic purposes and all that. In all these cases, they want access to your SMS box. They want access to your contact list. They want to access your photos. Almost whatever is available on mobile, they want access, and we have voluntarily relinquished this data. So this is creating a humongous problem, right? And then how to handle it. There is a positive part of it. There is also a challenging and negative part, because we have seen some of these, what is happening today in the social media platforms and all that. It can also create huge problems for us and all. So given the situation and all that, many of the governments have started probably looking into this issue seriously. How do you protect the privacy of the citizens, basically? So it's not that today only just we have this, in the last 2-3 years, we have these data protection laws in Europe. There are basically 3-4 regimes for privacy protection policies for us to bank on. As you said, first is the Europe one, GDPR, which is the most popular one. And then you have got the US, and then you have got Chinese, and of course you have Indian environment and all. But all these 4 are different kinds of objectives and different kind of priorities they have. For instance, in Europe, the priorities for citizen protection is the prime importance in all. In US, it's altogether a different model, laissez-faire. The state wants to intervene as less as possible and all that. It's all left between the individual and probably the social media platforms or any of the internet economy companies to do that. And in China is exactly opposite. They want everything to be under surveillance, right? A societal purpose they would call, not individual rights. Whereas in US, it's individual right which is supreme. In Europe, it is about individual personal liberty. So in India also now we've also caught up this, not because of certain legal cases that have happened in Supreme Court. So earlier prior to 2017, there were a lot of cases in Supreme Court which dealt with this issue of whether right to privacy is a fundamental right. So before 2017, there were conflicting judgments, some courts taking a view, it's an important right, whether you call it fundamental right or not. Some says, no, it is not enshrined in the Constitution in the fundamental rights list, so it's not a fundamental right and all. To set it rest and all that, Supreme Court has set up a 9 judges bench to take a final call. And we had the famous case of Puttaswamy, it is called. That is Aadhaar case actually. The 2017 Supreme Court judge delivered a judgment, very unequivocally telling right to privacy is a fundamental right. Right to privacy is a fundamental right. So that has made a very dramatic impact in India as well. And 2017, the judgment was delivered. In 2018, Supreme Court has also advised the government, you come out with a law for protecting the privacy of the individuals, 2018. And concurrently, government has appointed a committee headed by Justice Sri Krishna, who has submitted his report in 2018. So 2018, there was a draft bill, but again, it was not accepted. A lot of changes were made. So 2019, government has tabled a bill in the parliament to enact a comprehensive data privacy protection act. But now, of course, there were a lot of discussion in the parliament. It's presently under scrutiny by the joint parliamentary committee. So it is expected probably the next session, it may be tabled, provided, of course, JPC concludes its recommendations and all that, right? So the basic, of course, I don't expect much changes except 2-3 areas where maybe JPC may differ with the government draft bill that we will discuss as we go along and all. So, but the overall objective of this 2019 bill, number one, first and foremost, is protect the privacy of the individuals and all. At the same time, they're not taking it from a negative perspective. The objective of the bill, the government itself says, the objective is basically to unlock digital economy. So they are going with a kind of positive purpose as well. So we all know data plays an important role in digital economy. So while they're probably legislating, they would focus on how to unlock this digital economy. So one of the fundamental requirements for unlocking the digital economy is they have to build a trust between the citizen and the state. So the law is designed in such a way that there is a lot of transparency, both, I think, by the entities who are collecting, processing the data, and also people who are relinquishing the data. And overall, the government also will have a mechanism to enforce that the duties cast on data fiduciaries, as they call, are fulfilled. Yeah. So this basically is a little legal background and the social background. And to tell you that one more normally does not happen. That why the government is very keen on unlocking digital economy. They've also provided for setting up a sandbox, which normally does not happen. So the government would also set up a sandbox where if any of these innovative ideas come, but they can test whether the innovative ideas would probably comply with the data protection laws or not. So there is a positive spin to the whole process now. That's what's going on.
Okay,
so that is an overview, right?
Yeah, so that's a good good background to. So what we are saying, ladies and gentlemen, is that like other countries, we are also implementing data protection. Okay, each country has its own views on that, and so India is not far behind. It should happen sometime, perhaps next year, after the COVID is over. Perhaps we should see this bill coming through, and this is going to have a sea change in the way organizations deal with data. So there will be a lot of regulations. There will be a lot of fiduciary governance on all these, and so we should see a lot of action once this bill is implemented. So what are the major global trends in data protection regulations which are already enacted, and how are they different from what we are trying to do?
I think in US, the data privacy protection laws are highly fragmented. It is for sector. For instance, health sector, there is a privacy framework, HIPAA. For instance, the financial sector, it's called GLP. So they have got sector-wise some privacy frameworks and all that. There is no kind of overarching kind of a privacy framework which will cover all sectors. So that's an issue. And Europe, I think our laws are mostly modeled on European data protection, GDPR. So whereas I said that it has got 5-6 principles there, the first principle is this consent framework. So if anyone wants to collect the data, they should have the consent of the what they call data principle. Data principle means the citizen who is parting with his own data. He's called data principle. Yes. Data fiduciary is one who is collecting the data, processing the data, and using the data. So I think we need to understand these two kind of things and all. Mm-hmm. Number one is basically consent framework is common between GDPR and our proposed law, which is not final. I don't think it will change. That consent is another one. Mm-hmm. And then it also makes distinction in data, not the data we understand. Data, they have divided into 3 categories. One is the personal data. Number 2 is sensitive personal data. Okay. And number 3 is critically sensitive data. So, while personal data is basically any kind of information which can identify us. For instance, people can identify me by my name, by my photograph, even by my email, or even it is not simply about any of these attributes by which somebody can identify me. So I'm called a data principal, basically, right? So here in this case, a personal data is, again, they've said it's not merely about structured data, unstructured data, but also my political beliefs. Also would be a part of this data. So personal data or personal sensitive data. So then there is a sensitive data is basically about health condition, the financial condition, the sexual orientation, the biometrics, the genetic code, the religion, the political beliefs, and affiliations, this kind of a thing, because these are highly sensitive data. And then the critical data that the Act has not defined so far. They said probably Data Protection Authority, when once it is in place, they will define what is critical data. So the regulations would depend on whether they're processing personal data or whether they're processing sensitive data or they're processing critical data. So the law is not uniform. In fact, the rigor and severity is high in the case of sensitive personal data and critical data. Personal data, of course, it is only consent, and then which happens normally in most of these cases we use for our own probably social purposes or day-to-day financial purposes and all that. So one is that, the second is all the laws, they have laid down certain responsibilities for data fiduciary. So what he should do, he should maintain detailed records of what he's processing, what for he's processing, how long you would keep it. So as they say, purpose limitation, time limitation for all the data. It's not that earlier somebody collects the data, you would keep it forever. Now, once this law comes into force, they cannot keep it forever. And secondly, if they have collected for a specific purpose, which they have said, they cannot use it for some other purposes. So another important feature is that what is called right to forgotten, right to be forgotten. In the sense, once the purpose is served, the data shall be deleted from the data fiduciary records. And then it also, another right that is given across all these laws is right to access the information. Anytime I can ask data fiduciary, tell me what is the data you're holding as of today. If you have shared with other people, tell me with whom you have shared. In all one place, give me what are you doing with this and all. So basically, and then all the laws confer rights on data principle. So he has been given a lot of rights. As we go along, we'll discuss. So basically, it's about consent framework. It's a right to be forgotten, a right to access the information, a right to correct it. So these are all something common in the GDPR, that is European law, as well as our proposed Indian law. Is that okay? Or little abstract, of course, because only when we get some 2-3 cases, I think we will come to know.
That is true. That is true.
So basically, it's about, lot of rights are given to the citizens.
Okay.
See, those days are gone. Supposing I download an app, right? I give now I give a lot of permissions. You can access my SMS, you can access my contacts, you can access my photos. But now he has got to tell me what for he's probably collecting this information and how long he would keep it.
True.
And then supposing we all have given 20 platforms, all of us would have given. So we have no idea, right? So now we can get, and then on an ongoing basis, this is one of the, I think, one of the major objectives in this law, giving protection, giving rights to the data principle, which did not exist, even though we had some rules, but I think that were never enforced. We have got that under IT Act 2011, certain rules were framed.
Okay. So, like any other governance that is required, because this is going to be massive, right? So, because data of 1 billion people around are going to be stored in maybe in each corporate, in each social media channels, etc. So, is there going to be a governance fiduciary which will oversee how the entire data has to be maintained?
Yes, definitely. I think the bill provides for establishing what is called Data Protection Authority, right?
Okay.
Which would oversee the implementation of this act. For instance, data fiduciary, that is the entity which is collecting the data. The act has laid down very clearly certain obligations on the fiduciaries.
Okay.
Right. First of all, they should not collect any data unless there is a consent. And before collecting, consent should be specific. You should tell while collecting itself, I'm collecting this data for this purpose. And it should be very clear. It should be fair. Not that you would say that I need all this data for a very vague purposes and all that. It is not accepted. It should be very clear. And then it is capable of being understood. And then he has a responsibility to see that ensure that privacy is protected. For that, he has to maintain records. To demonstrate the entire data life cycle from collection till it is deleted. What is the governance process he has? Who are the people who are responsible within the organization? So there is a provision for appointment of data protection officers who will be a very important functionary, who will be probably a link between the organization and data protection authority, which is going to be established after the law is passed. So And another responsibility that is cast on this, what is called data fiduciary, is that he should also record the nature and categories of data he's collecting. And he should also, in case he has given it to somebody else to process, he should identify and he should inform the data principal, that is the citizen, that he has given to somebody else for so and so specifically for processing. And then I can withdraw my consent anytime. Anytime I can withdraw.
Yeah.
So before this act, what happens is there was what we call a power asymmetry. Data fiduciary is more powerful as a citizen. I don't have any much power, right? So this act proposes to probably restore some balance between data fiduciary and the citizen. So to have this, entire governance process, there is a detail. Of course, the rules would come, I think, probably once the data protection authority is established. But this is already provided for in the framework.
Okay.
So, as I said again, he cannot transfer, he cannot store, he cannot process anywhere he wants it. But he needs to keep the data, the citizen informed what is happening.
Yeah, very true. So, ladies and gentlemen, I hope you're getting this very, very big change that is coming up in terms of how data is going to be stored in every organization. It's going to affect you, it's going to affect me, it's going to affect every organization. That it is your responsibility to ensure that data is protected. Okay, that is the customer data, the vendor data, the supplier data is well protected, and it doesn't just go out. And you have got to demonstrate that you have got compliance in place, and the data privacy protection compliance. You have to kind of perhaps prove that. So while I continue to have a discussion with Mr. Murthy, if you have any questions, do put in your questions in the chat box, in the Q&A box, and we will try to get it across to Mr. Murthy. Should you want to ask a question directly to him, you could do that also. Raise your hand and our digital team will take you across, and questions can be asked directly to Mr. Murthy and he could answer. Like always, please ask your questions which are directly related to this subject and not any other subject, please. So let's be clear about it. Mr. Murthy can talk about a whole lot of range of topics besides data privacy and finance. But stick to the subject of data privacy, and that's what we want to do. So I look forward to your questions, and so let's take it across. As you know, people are there, Mr. Murthy, from not only on the EPS channel, they also are coming through YouTube, Twitter, Facebook, and LinkedIn too. So audiences are watching and hearing, and so all are welcome to send their questions as soon as possible. Mr. Murthy, one of the things that will happen is that each country has its, you said, is adopting a practice, a law, which is more suited to their kind of environment. So we are also adopting a certain kind of laws which are for protecting, individual privacy, unlocking digital economy, having data fiduciary, and you also setting up of a sandbox to kind of ensure. So these are all our thoughts. So similarly, there are thoughts. Europe has adopted GDPR in their own way. Similarly, Brazil has adopted, Singapore has adopted. So what happens if a company in India has to, of course, adopt the local laws? But if they are dealing with a company in Singapore or dealing with a company in Europe, do they have to also demonstrate that they are compliant with those countries' laws also, or showing that we are adopting Indian law is good enough?
No, my sense is today, I think you have raised a very important issue, which
so we can't hear you.
You have raised a very important issue, which is not settled. See, one argument is data has no territory, right?
Yeah.
I may be Indian citizen. My data may be stored in cloud somewhere in Singapore or US or Europe, right?
Yeah.
So data has no territory as such and all that. So while each of the individual countries have their own laws, my sense is, I'm not a legal expert and all that, they have to comply with the laws of the respective countries. For instance, if there is a company in India processing the data of the European citizens, GDPR requires they need to comply with the GDPR law.
Yeah.
Right. So today, what happens with the Indian law? Of course, so far as the governance mechanism which you have raised, there are more or less same, but there are specific provisions in each of these countries. Everything is not uniform and all that. They have to comply with multiple laws as of today. Like you have some income tax, right? Income taxation also is an issue today, right? Of the multinational companies.
Yeah.
Right. So there are a lot of unsettled issues. That is it the place of business, or is the place of the customer? Is it the place of the probably principal establishment? So all those issues are there, right? So I think one day, I mean, people are talking of, just as we have World Trade Organization, you may have World Data Organization, right? At least some broad principles being accepted at a UN level, or even at least probably it would start with G7, G20, ultimately it may go to UN level. I think at least some common framework to do that. But till such time, I think they will have to comply with the multiple laws. They have no choice. Whatever applies to them, they need to comply.
Okay. Thank you, sir. So what are these? What are the rights of data subjects, and what are the opportunities there?
So there, basically, again, as I said, while he has got the rights and all that, so all the especially in India, very clearly mentioned in the objectives of this bill itself.
Yeah.
Unlocking digital economy is also one of the main subjects. So they want to balance the needs of digital economy and the rights of data principle, right?
Yeah.
So basically, rights basically tells us that I'm in control of my own data. I'm empowered to deal with the data whichever way I want it. I can give my consent, I can withdraw my consent, right? I can give my consent for a specific purpose. I can tell them for how long they can keep it, and they need to keep me informed. So there are 4 or 5 rights which are important rights, as we said. One is the called right of access and confirmation. So basically, I should be able to access my data with any data fiduciary, right?
Yeah.
And I have a right to know what is the process data fiduciary is following. I can also ask him what are the process activities. And then I can also ask for a brief summary of where all my data, the data fiduciary is shared. So first is right of access and right of confirmation. Today, if I ask any of my, say, WhatsApp provider or any of this Facebook and all that, there is no obligation on the part of data fiduciary to give it. But now once the law comes into being, I'm conferred certain rights. Second right is that right to correction and update. I would have given my data 4 years ago, 5 years ago, right?
Yeah.
But today I can ask him, tell me what is the data that you have, and then I can have a look at it, say that these are all the changes that had happened in my case, and you should correct it so that they are not misleading, and then they are complete and they're up to date. And most important thing is third right is what is called right to portability. In the sense, if I have my data with, say, the Facebook, I can ask him to transfer my data to some other platform. So this is very important in the financial services sector, portability. In India already we have implemented it, what we call is data aggregator, right? Already 4 or 5 data aggregators are in place. Supposing I've got 3 or 4 bank accounts, I'm applying for a loan in one of the banks. I can authorize a data aggregator. You collect the data from all these 4 banks and pass it on to him, right?
Yeah.
Portability. So I don't have to go around to each of these banks or each of these agencies, government agencies, or a GST return is there. So supposing I apply for a loan, bank would expect me to give me the GST return. What is the turnover? With what are all the banks I'm dealing with? What are the transactions and all that? What is the balance I have? How much money I have borrowed from each of these banks? By just click of a button, I can authorize one of the data aggregators. There are 4 or 5 in India, but I don't know how many are operational, real operational. I think pilot runs are going on. So right to portability. So this is very important in the financial services sector. And also it is also useful in the case of healthcare. We always take second opinion, third opinion in some critical cases, right? Yeah. So I can ask one of the hospitals, say that please transfer all my health records to so-and-so hospital, right? Yeah. So right to portability is a new kind of right which was not there. And these guys should give it in a mission readable form so that the whole process gets automated. And then most important is right to be forgotten, in the sense that when once the purpose is served, he has no business to keep my data, right? Yeah. I can tell them that, you please delete my data. I would not like to be in your memory, right? We forgotten in the sense, I don't want to be in his system's memory. But there are certain exceptions in the sense that supposing I take a bank loan and then without clearing it, I can't tell the bank you delete, right? Or even if I clear the loan, I cannot ask him to delete it because he's also required to maintain the records for a specific period under its own laws, right? Mm-hmm. So 4 or 5 rights which are common, which are GDPR also earlier, you asked me, in the basically right to access, right to corrected, right to erasure of the wrong data, right to data portability, and right to be forgotten. These 4 rights are common and with GDPR, and these are all very important. But of course, the real test of these things will come when the disputes arise between data principal and fiduciary. So I think it gives why the rights are there. So basically, when once I have these rights, I can freely share my data, right? And when you are living in a data economy, and unless we share the data, probably with the entities, various entities concerned, they will not be able to do analytics. They will not be able to understand us better. Mm-hmm. So this will help digital economy.
Yeah, very true. Also, if that's a law, and every organization is supposed to maintain certain, has to demonstrate. Is there and if it is not being done, and if it is proved it is not, that data has leaked out, are there punishments, penalties on the corporates? And if so, how are they going to be implemented?
Yes, you're right. And the penalties are quite steep. There are several categories and several categories of penalties for depending on the nature of the breach, severity of the breach, and the scale of the breach. Mm-hmm. So the highest penalty is 15 crores or 4% of the world turnover, whichever is higher. Mm-hmm. Imagine 15 crores or 4% of the turnover, whichever is higher is the highest penalty. Yeah. So that, and there are a lot of penalties, supposing as the government's mechanism that they're required to maintain records. If the records are not maintained, there are penalties for each day of default and all that. And then in case they do not submit returns, they would also levy penalties. But again, as I said, it ranges from anywhere from 5,000 per day to 15 crores. Okay. Is the range of penalties. There are at least about 12 categories of penalties.
So come again on the penalties. Let the audience know what's the kind of penalty can be levied.
As I said, there are more than 12 categories, and most of them penalties are levied and data fiduciary, right? Okay. So earlier we discussed what all he's supposed to do, a governance mechanism he has to do. He has to maintain records. He has to inform the data principal what he's doing, what he's collecting. So supposing if he collects for a particular purpose, he uses for some other purpose, there is a penalty, right? Okay. And the data as a citizen, I ask them to give me access. If it doesn't give, there is a penalty, right? Yeah. And then there are a lot of returns that are required to be submitted to data protection authority. If they're not there, depending on the again severity, there are huge penalties. And then because there is, of course, there are again provision for adjudicating officers. There are provisions for appealing. So the 4% penalty, even in GDPR Europe, there also penalties, highest penalty is 4% of the turnover.
Oh,
of course, there is 20 billion, for us it's 15 crores.
Yeah, steep. So, ladies and gentlemen, as you see, what's coming is that if you are unable, if organizations are unable to keep data confidential and not leak it out, or by mistake also it goes out, penalties are going to be very high. So, we've got to have proper compliance. So it's going to be that much more difficult to ensure that data actually does not get lost or stolen. So, Mr. Murthy, I have a question to you from Mr. Rajesh Sharma. He asked a question: how would it impact small and medium businesses like, say, cooperative banks, credit societies, small hospitals, accounting firms, maybe even small clinics, doctors? How will it affect them?
So basically now I think the Act provides for making a distinction between significant data fiduciaries and the small fiduciaries, small entities who have to collect data in the course of their business, right? They have to collect data of their customers, consumers, for discharging their duties and all that. So far as these small entities are concerned, I don't think the rigor of penalties will be very high. The requirements of keeping the records and all that also may not be very high. So, but for information companies, they are not information companies. They're basically commercial companies. It is only natural that they need to collect the data. But having said that, they will have some responsibility to keep the data very confidential. So, as I said, if somebody asks for information as a patient, supposing asks for information, it's not easy to get from an hospital even, right?
Right.
Or even if I ask for my big commercial establishment, it's not easy to do that. Tell me, problem is today I want to go and buy some commodity. Okay, fine. Yeah, I pay either cash or I pay by card or whatever it is, and he gives me invoice. But if he starts collecting the data, you give me your name, you give me your family details, you give me my mobile number, you give me my email address, right? He asks so many things, right?
Yeah.
So if he is collecting it, obviously he has to take some care to do that. Otherwise, the data can be disclosed outside, right?
Yes, absolutely. Yeah, true.
So, but I don't think that the penalties will not be severe, but there will be responsibilities. Okay, he becomes a data fiduciary.
Yeah, that's correct. Thank you. So you're saying that even if it's a small organizations, they have to maintain a certain amount of compliance. They have to demonstrate perhaps, and be there, may not be as rigorous as the bigger organizations. Okay, thank you, Rajesh, for a good question. Sir, when we design IT, when we make IT systems, we have various considerations to do it. So going forward with this law, will privacy by design be a habit with the IT systems?
Right, that's very, very important question. That let me also tell you regarding penalties. There is one very severe penalty which probably there is an imprisonment even for that, for the violation. For 3 years imprisonment, non-bailable.
Oh my God.
That's what is provided in that. That basically penalty is levied where, when some people process large amount of data, they anonymize, right? They take out the names and identifications, personal identifications when doing it and all. Mm-hmm. Supposing somebody mischievously does re-identification mm-hmm. without the permission or the knowledge of any authority, because that's a very serious issue, right?
Yeah.
So that would attract jail term of 3 years, re-identification, because anonymized kind of a situation and somebody tries to try to understand who are the individuals and get their data. That is a very severe offense.
Yeah. Okay.
So that's a penalty part of it and all. So privacy by design is a very important provision. Basically, this is a part of the governing process of data fiduciary, who is collecting this data. So what is privacy by design? There are about 4 or 5 elements to it and all. As I said earlier, that these people have to maintain a lot of records, right? Documents to prove that they are complying with the various provisions of the law. The first part of the first component of the privacy by design is basically you should prepare a record of who are the managerial personnel, what are their roles, what is the organizational structure, how the data flows across the organization, what are the business practices they're following, and what is the technical system. Basically, they do it, they probably implement. Again, at the end of the day, to see all these managerial systems, organization systems, business practices, technical systems, they should be designed to prevent harm to the data citizen. That is the purpose of the design. The purpose of the design is to prevent harm to the citizen, at least minimize, mitigate, and remove whatever harm that can happen. Second is basically, they should also document what is the technology used in processing this data.
Yeah.
And these should be commercially accepted or they should be certified by independent agencies.
Mm-hmm.
And they should record the legitimate business interest should be part of the design. And if they want to do innovation, even that need to be recorded and then explain in detail how does it benefit the business, how does it benefit the data principle. And then they should also, by design, they should prepare how throughout the life cycle of data, how they are protecting the privacy part of it. And there should be absolute transparency. And then the interest of DP is paramount in all these cases. So privacy by design is nothing but say that it's not by afterthought. Like even in security, we say security by design, right?
Yeah.
It should be there as a part of the development process itself. So here in this case of, data process or data analytics, they do that. So they need to be very clearly say that, even in any organization, like marketing organization, these fellows sales, this fellow originate, this fellow gives leads, this fellow would probably take a call, right? So similarly, you need the entire managerial structure and entire organizational structure, how the data is flowing. At no point in time that privacy shall not be compromised. That is the purpose by design.
Right.
So if somebody wants to use artificial intelligence, right? They need to be very clear what is that rule engine, right? What is it? What are they trying to probably get the output through artificial intelligence? What is that rule engine model? They need to document all these things. So this is privacy by design. And then in the case of significant fiduciaries, this design has to be approved by the government before they go ahead.
Yeah.
If they want to do large-scale profiling, if they are processing data of millions of citizens, they should give what is called the privacy by design policy. They should document it. It should be verified by data protection officer, and it should be submitted to data protection authority, who will be appointed by the government, and then they can do the detailed profiling. But for large-scale processing, it happens. So the privacy by design is one of the important provisions of the proposed bill.
Okay. So let's take a question from the media. So Krishna Tripathi, who's our regular participant, Krishna Tripathi would like to ask a question. He's from ETV Digital. Mr. Tripathi, can you please unmute yourself and ask the question?
Yes, sir. Am I audible?
Yes, please go ahead.
I just wanted to ask you, these companies, these tech giants like Twitter, Facebook, Google, they are collecting data more than what is necessary in order to avail their services. Somebody creates a Twitter account or Facebook account. What happens recently? They will describe the account as some suspect account, and they will ask for the phone number and other verification or IDs. How we can discourage these companies from collecting this data? It's a big problem.
As I said,
bigger problem than the data leak.
Right. So even if you see that in the Act itself, they've recognized some risk of the activities of the social intermediaries. So they said even threat to electoral process, threat to democracy, threat to public order, threat to sovereignty of the country. They mentioned in the Act itself that the social intermediaries have this as an issue. So as you say, supposing somebody says a part of the process, give me this mobile number or give me this email address and all that. So once the purpose is over, you have a right to say that, okay, have you completed the process and all that? The process is there, that please delete it or erase it. So there cannot be indiscriminate collection of data and storing of data and processing of data. Three elements are involved: collection, processing, storing. So they cannot store it for times immemorial, right? When the purpose is over, they got to delete it. And they cannot process it for any of these things. See, earlier what happens is they just go on collecting the data. Even they don't know what for they're collecting. Probably their product development, their marketing organization, later on they find, okay, this is the data and all that, let us develop a product. So that cannot happen when once the law is enacted.
Okay,
Am I
thank you,
clear?
sir.
Thank you. Thank you, Mr. Tripathi, for a good question. So in IT, generally, IT systems, we always classify a risk, whether it is high or medium or low risk. Going forward with this law coming in, will we also have to classify data as high, medium, and low risk?
Okay, these rules have to be framed. They are not provided for in the Act.
Oh, it has to be framed. Okay.
No, they have to be framed. They're not framed that.
Okay.
So ultimately, they would say that the privacy is the privacy compromise. That's what the government is interested in.
Yeah. That's
So
right.
privacy problem is that, what happens is privacy is not compromised. Many of us, we relinquish our privacy, right? Some app I want to download, you would ask for, Hazar information and all that, which is not related at all. I'm giving it, right? The problem is the privacy policy. You will say that I agree with the privacy policy. I have no option, right? Consent also, they say, the consent is also weak. The problem is that supposing I want to download an app, you would ask me, you give me permission for your contact, for your photographs, for your SMS messages, all these issues and all.
Yeah.
So here in this case now, either if I want to subscribe for that, if I want to use the service, I have to give permission, right? I have to give consent. He meets the requirement of law. But supposing there is no say that, okay, you have asked me 6 permissions, I'll give you only 4. But there is no provision in the privacy policies, right? As of today.
Yeah. Yeah.
So the consent also, many people argue that, consent is not very effective. Even in Europe, they find out, because privacy policy is not easy to understand, right? So I've seen somebody sent me a privacy policy and asking me that runs to 18 pages.
Okay.
18 pages. So only a lawyer can understand. So again, we say that consent is central to the entire act, and the consent based on privacy policy accepted, because today either all or none, right? So there is no granular way. I say that, no, you have asked me 6 permissions, I'll give you only 4. You would say that don't subscribe.
True.
I will not be able to use the service. So it's a question of trade-off for me.
Yeah.
So these, of course, as we go along, that I think we'll understand.
Sure, absolutely. I think, we will have to wait for the laws to come out and get more clarity. But I think we are discussing what's coming up, so that's very important. So most of it will come up. So one of the very sensitive things about data is the influence it can have on elections. We already are talking about that. So and so country can influence the elections in the USA, and things will happen, and this is going to happen because they don't like so and so, etc. So with this kind of a regulation that comes up, and which says that this is where data has to be kept and this is where it is stored, is there a chance that even the data that is stored with us can be used for political purposes?
I think, I don't know whether you have an occasion to see the deposition of all these, FANG stocks, that Facebook, Google, Amazon, right?
Yes.
And then where this one of the questions that are asked for, right?
Yeah.
And the answer given by most of these people, in the words of senators, I'm not saying that, they are evasive.
Yeah.
And then we know the case of Cambridge Analytica, right?
Yes,
about 70 million data Facebook is given, and then they say it's used for US elections or even Brexit voting and all that. They say even about 5 lakh the data of Indians are also involved. They also try to use it and all. Yes, this is this risk involved. And then, there is a documentary, I don't know whether you have seen, Social Dilemma. which is happening to why these people are doing all this, but interfering in the elections or even getting into the social divisions in some of these countries and all. They said, they are not doing on purpose, but it's a part of their business model itself. One of the probably bad byproduct of their business model. So they're collecting as much data as possible. But today, let us see that today, now supposing they have been fined also. So probably, when once probably court finds them guilty, they have to pay the fine. Yeah. But it doesn't matter because so long as it is small part of their profit.
Okay. Another question that has come up is that, we have this, in cybersecurity, we do this vulnerability assessment just to check, where could be the problems, vulnerabilities across the IT infrastructure. So even fire drills, if you see, are done, once in 6 months or so, wherever possible, so that in case of a real fire, you know exactly what to do. Do you think that with this enactment of law, privacy impact assessment will become something of a requirement in the days to come?
See, privacy and security are two different aspects. They're completely two different aspects. Security is one part of privacy. In the sense, supposing if there's a breach of security, obviously privacy is also breached, right? You have to see from that perspective and all that. So that these organizations have to continue to do that about breach. Today we are talking of privacy. Privacy in the sense that we are talking of more misuse by the fiduciary, right? Collecting for one purpose and using it for another purpose, storing the data beyond what is required. So even here also, they do vulnerability tests. Here, privacy by design, there is a clause where they have to do an impact assessment.
Yes.
Whatever process I do, what impact it has on data privacy. So here also there is a provision for doing impact assessment, how it impacts probably the privacy of the citizens.
Okay.
But it is totally different from vulnerability analysis and all that. That will continue. That's a different branch altogether.
Okay. So my last question to you is, it's important to know the financial impact of potential data breach. People would like to know that. It's estimated, even for cybersecurity, people do estimate that. So if you want to estimate the probability of a data breach and its financial impact on the business, is there any methodology by which that organizations can be ready with some kind of risk assessment?
Yes, the Act provides for compensation to the data principal in case of, my data is disclosed without my authorization because of a breach or by accident or by design, right? If it happens.
Yeah.
So the Act provides for compensation to me, provided there is a harm, either a physical harm or a financial harm or harm to my reputation, right?
Yeah.
Or it has impacted my employment, it has impacted my business. So if I can prove because of this breach and all that I'm entitled for compensation. But the Act does not spell out what exactly is the compensation. They say Data Protection Authority will decide what will be the compensation.
Okay.
And it depends on the severity. And also it will depend on what are the precautions he has taken, as you said, vulnerability like impact assessment, what he has done. So it depends on all that, then they would award compensation.
Excellent, sir.
Provided there is a harm. Provided there is a harm.
So go ahead, sir. Sorry.
No, provided there is a harm. I have to prove that I am harmed, either physically, financially, reputationally, business-wise, employment-wise.
Yeah. No, I'm looking at it from a risk provision point of view, such that corporates say that in case something of this sort happens, this is the kind of provision we got to make from a risk point. So some such methodology is there. So when the law comes out, we will perhaps know. That's what you are saying.
It can be covered by insurance, good insurance business. Like, we all take, cyber security insurance, right? So we'll take insurance for the data privacy protection.
Yeah, that's true. But it's the same problem. Like you want to take a cyber insurance, right? Question is, how much? Is it 10 crores, 50 crores, 90 crores, 100 crores? We don't know. Unless you do a proper assessment,
Yes.
Only then you are in a
Yes.
position to say, this is the right insurance I want, because you don't want to pay too much of premium unnecessarily, or you don't want to underpay premium so that you get affected. So, the right optimum number is something that has to be come through some methodology. So we are coming to the end of the program.
Thank you.
Because it's a new topic, will you like to summarize and or give us a view to the audience as to what's there? You covered most of it, but is there anything else there? Yeah.
To sum it up, basically the bill itself, specifically mentions one of the main purpose. There are two objectives of this law. One is to protect the privacy of the citizens. At the same time, unlock digital economy. These two twin purposes. They look conflicting, but they're not conflicting, right? So if they want to unlock the economy, digital economy, and also protect. So three important provisions, I would say. They've cast a lot of obligations and data fiduciary. Data fiduciary is the one who collects the data, processes the data, stores the data, right?
Yeah.
A lot of obligations. And then number two, he has to demonstrate a governance process. And the second thing is they have conferred a lot of rights on the data principle today, which I don't have, right? So like, I have a right to access the information. I have a right to give the consent. I have a right to withdraw the consent. I have a right to be forgotten. So they have very clearly defined these rights and all. And the third thing is the Act provides for establishment of a data protection authority.
Yeah.
Today, even though that we have got under IT Act, they put the rules and all that, most of the rules are already there, but we didn't have a good enforcement machinery. So the Act provides for a good enforcement machinery and all that, but it will take, my sense it will take maybe a year or two, because even GDPR in Europe, they have announced it in 2016, but they've given 2 years time for all people to put in place the systems. So they will have to probably give some time for all the organizations to put in place the system. Once the Act now works well, it will, I think, generate a lot of trust between citizens and the fiduciaries, and which will be good for the digital economy. Of course, there are a lot of, issues that, people are not happy, like saying that government is exempted from a lot of these provisions of the Act. So those issues are there, but I'm sure it is still at the final stage, and some of these issues may be addressed there. So I expect basically it's about, rights of the citizens, obligations of the fiduciaries, and enforcement machinery, and with clearly defined objectives of unlocking digital economy.
Thank you, sir. Well summed, sir. So, ladies and gentlemen, we come to today's end of session. I hope you enjoyed this discussion that I had with Mr. Murthy. This is a big change that is coming. Okay, the protection of data is going to be extremely important, and there's going to be a lot of things happening. I would compare it as good as the rollout of GST. It's going to be that big, because every organization, big or small, is going to be impacted, and you have to have certain principles, certain policies, such that you are in a position, you're showing resilience in data protection. That has to be demonstrated, because if you don't, and if it is proved tomorrow that data has leaked out from this organization, the fines are very heavy. Like you have in GDPR in Europe, India also is going to penalize heavily if data is leaked out by organizations. So, a lot of things coming out there. So please join me in thanking Mr. Murthy for a decisive, very good and analytical thought on what's coming up in the days to come. And once the law is enacted, I'm sure we can have many more sessions with him, and we can get to know more about data privacy in India. With this, can I request please join me in thanking Mr. Murthy. Mr. Murthy, thank you very much for coming, and a good evening to you.
Thank you. Thank you very much for having me. I hope that is useful. Some light has come. Okay.
Absolutely, sir. It was wonderful talking to you. I must tell you that. Ladies and gentlemen, before I let you go, on Friday, the 16th, we are having another very important panel discussion. We've had 2 panel discussions already on the new umbrella entity. Okay, this is another path-breaking proposal that has come from RBI. The third one we will have on this Friday. So there is a small video that we would like you to see, and have a look at that, and do join us on Friday. And with this, I kind of thank you and wish you a good evening. Thank you very much.